Good morning, Dr. Belesi. Good morning, Ms. Okoko.
Hi, Stanley. Good morning. How are you doing?
I'm okay. Good morning, Mr. Nado. Am I pronouncing it right?
Sorry, are you speaking to me?
Yes, Mr. Ginado,
Yes.
right?
Sorry, yes, Junodi, yes, Junodi.
Yeah, okay.
Hi,
Hi, Dan.
Abdul.
Hi, Dan.
How are you?
I'm all right. You recovered from Riyadh?
Well, is there any recovery from Riyadh? Is there any recovery? But it was good. After I don't know if you left before me or I left before you, but
Mm,
immediately I came back, I immediately had to jet out to London again. So I got back from London just two or
yeah.
3 years ago. And it was some sort of an aftermath of Riyadh, actually, some fallout from Riyadh. So this is the reason I say, is there some recovery from
Yeah. No, I left very early on Thursday morning to go to Dubai. I was in Dubai for almost 2 weeks. I just got back from Dubai as well. So yeah, I can appreciate the constant jetting around.
Well, it's the life we've chosen, right?
Exactly, exactly.
Stanley appears to be so relaxed. He's just
Yes.
enjoying this life, having
Things are
fun.
not always the way they seem. Things are not always the way they seem. Actually, in Toronto now, and it is 5 a.m.
Oh
Oh,
no.
where are you?
In Toronto.
Oh, okay.
Yeah.
Oh
Oh
dear.
my. Oh my. Oh
So
my.
like I said, things are not always the way they seem. I've been up wearing a suit since 4 a.m.
Well,
Like I said, it's this life that we've chosen, isn't it?
Yes.
Okay, so we wait for
we're
Mr.
waiting
I'm just waiting
for
for, yes, Mr.
our,
Oh,
our,
she's,
our senior.
Yes,
yeah, I've
so
seen her. Yeah.
okay.
I've admitted her.
Okay.
Okay. Good morning, Miss Sadekoya.
Good morning, Ma.
Good morning. You have disabled my video.
Stanley.
No, I didn't. Let me see. Um,
There we go.
okay.
Okay, all right. I'm good.
Good
Nice
morning,
to see you, Stanley.
Good to see
My
you,
ju
ma. How are you?
my junior wife.
my senior. I'm fine, though. I'm working, though. I'm doing very good work. Even this morning, our husband
You're
was
taking care
so,
of our husband.
yes. So as at this morning, he said, you're doing a good job. So I'm happy that
Uh,
I'm holding forth for all of you.
carry on, carry on. Abdul, I had the privilege of listening to a lecture from Professor Adele Jinodu yesterday. I was
Okay.
I was bowled over.
Okay, so just very quickly, I just wanted to talk about timing.
Mm.
I'll see if I can create a private chat where it's just the four of us. Let me see if that's possible.
Mm.
Um, Belosi, please, is this something you can help with? Just to have a chat with just the 4 or 5 of us, and I can put in time, how much time is that is remaining.
That'll be very useful.
Sorry, to contact with them individually.
It has to be individually. Okay, okay.
Yeah, yes, individually, yes.
Okay, so please, I'll post time. So I'll put in my time, and I'll nudge you when it's maybe a minute to go. Because for some of the questions, it's just about 3 minutes.
Yeah.
The truth is, I've attended a bunch of these webinars, and we're going to be, the chat room would mostly be filled with Supreme Court numbers because a lot of people are just joining in for the
Yes, yes.
BBD point. So I'm
Told
not
them,
sure there'll be a whole lot of substantive questions. Maybe people saying nice presentation, thinking that maybe when they comment, they now get the number, the point or whatever. But it's just the most important thing I think for us is just to keep to time. I'll
No,
drop
okay.
messages when it's a minute to go.
Stanley,
Yes.
Stanley, just to help, I'm going to disable the chat, and then when it was the time for you to ask the questions, I will sort of open it again, just to keep that noise and that.
Got it. Okay, that's fine. So,
Yeah.
and then when that happens, I would screen through the questions and pick one or two questions or three, depending, and I can put it open to pick to address, or I can address it specifically to one of you. Dr. Bliss, would you do a general introduction, or should I just start?
No, you just start. All yours.
Okay. I think that's it. Then, if we finish on time and there are no questions in the chat room, is it okay for us to end, or do we have to wait until?
Yes, you can end. Just when it's 5 minutes, 5 minutes before you end, invite Mr. Adibomori to give the closing remarks.
Okay.
That's all I have to do. Just 5 minutes to the end, call Mr. Adibomori.
Okay, got it. Okay. I think that's fine. Any questions from our esteemed panelists?
Only to ask who's introducing you.
Nobody is fine. I'll introduce myself.
Make sure you mention you're in Toronto at 5 a.m. your time.
No. Security reasons. And my villagers. They will all join in looking to see what I will say.
Well, we have a fair number of people who are joining, so hopefully it won't just be for the points.
Fingers crossed. I'll probably give maybe like 2 minutes before we start. Then we'll kick start.
Okay.
So for the first question,
it's for me.
5 minutes. And for the question, it's for you.
Yeah.
It's still the same questions, right? But that's phrased differently. Yeah.
So, Diane, I thought you went to Paris Arbitration Week.
No, after Riyadh, I went to London and I only just came back. So, you know, this domestic wife thing, we have to take care of these husbands, you know.
That is true. So how was Riyadh?
Riyadh was good.
Abdul was
You were there as well?
Yeah. And Paris isn't until March. Paris is end of March after Ramadan.
Okay, yeah. Paris is end of March, yeah.
But for that one, I'm not going.
No, I'm not. Yes, I'll be at ICA.
Okay.
Yeah.
So maybe we'll catch up there.
Yes.
No, Riyadh, I went for the first one. Was it the first or the second? I think I went for the first one. I was there for all of 24 hours. So.
Oh, wow.
I can say I saw the airport and I saw the conference venue.
I was so impressed. Mad, you know, from touching down to getting to my hotel was exactly 20 minutes, and I got visa on arrival.
So you see?
It was so smooth, so easy. Just go get them. And I was like, wow, this is so impressive.
Honestly. I mean, they've got the money to push into it. Whether Riyadh will ever become a center of arbitration in that
bigger question.
Yeah,
that's a bigger question.
Okay, so
yes.
Well, I guess we're ready whenever you are. Stanley.
Yes, I am. Let's just wait for 2 more minutes before we begin.
Okay.
Hi, everyone. Good morning, and thank you so much for joining us. My name is Stanley Nwekeze, and I'm a managing counsel at Templars based in Lagos. On behalf of the Chartered Institute of Arbitrators Nigerian branch, I warmly welcome you to our February monthly meeting, and today's webinar title is Construction Arbitration in Practice, Managing Risk, Delay, and Disputes in Complex Disputes. Construction arbitration remains one of the most technical and demanding areas of dispute resolution today. Complex contracts involving project scopes, delay claims, valuation challenges, and the heavy use of expert witness and evidence all combine to create disputes that require both legal and technical sophistication. Today's session is designed to unpack these issues in a practical and accessible way, drawing on the experience we have on today's panel. Talking about today's panel, we are privileged to have 3 esteemed colleagues join us today. In no particular order, we have Mrs. Funke Adekoya SAN, who is an arbitrator and litigation consultant with Funke Adekoya & Co. We also have Mrs. Diane Okoko, who is a principal partner at Marcos Okoko & Co., a law firm based in Abuja, Nigeria. And we have Mr. Abdul Latif Jinadu, who is a practicing barrister and arbitrator in Keating Chambers in London. Each of them bring decades of experience in arbitration, specifically construction disputes, as well as litigation advisory. So the format for today would be 4 structured rounds of discussions, followed by a 25-minute Q&A session. At that point in time, please feel free to drop in your questions in the chat box, and I would speak to them and allocate them to one of the panelists to address. So before we begin, we'll start with the foundational questions first. And let's start by giving our audience some grounding on the core issues that would typically give rise to construction disputes and also would shape the arbitration process. So going to you, Mr. Jinadu, you've handled a wide range of construction disputes. From your experience, what trends tend to spark these disputes, and how do they evolve into full-blown arbitration? Thank you.
Thank you, Stanley. Thank you, everybody. Good morning. I have a useful shorthand when I'm asked this question. Construction disputes fall into 3 categories. It costs too much, it takes too long, or it's falling down. It tends to fall into one of those categories. So dealing with each of those in turn. Cost too much. Well, it's pretty self-explanatory. There are 2 categories of things costing too much in a construction contract. They're things that I call internal issues and external issues. Internal issues usually revolve around questions of variations and unexpected things happening in the course of the contract. In large infrastructure disputes, the form of procurement that's generally used is the EPC form, which is engineer, procure, construct. The key there is that you have the design risk is placed on the contractor. And in those sort of contracts, you tend to have disputes about variations because the contractor will say, well, either I've designed this, but you changed the design parameters, or your initial specification wasn't clear enough. and I've had to do something different to what I was going to. So here's the variation, and I want more money. The other source of dispute is things unexpected happening in terms of ground conditions, for instance. So on an EPC contract, depending on the form of contract, the risk for ground conditions will usually lay with the contractor. The contractor will say, well, actually, I came along to do my work, and I found that there was this huge sewer in the way, which the ground surveys you gave me, on which I based my contract, didn't show. Therefore, that's a variation, and I want more money. Then those are generally the internal factors that can cause cost escalation. The external factors, which can cause cost escalation, are things outside the contract. So, for example, in Nigeria, we've experienced in the last few years huge currency fluctuations. That's going to have an impact on the profitability of the contract. From simple things like the inputs the contractor uses to carry out the work. So he has to buy diesel. He has to employ labor. If there are huge currency fluctuations and add on top of that inflation, that's going to have an impact on the contractor's bottom line. And that gives rise to claims by the contractor. He will say, well, I didn't anticipate this when I signed up. Your currency has devalued by 100%. Then I want, and that's raised the cost of things I'm bringing in. So if I'm buying diesel, I'm paying foreign consultants. Those costs have increased. Therefore, I'm making a claim. Now, whether or not those claims are permissible will depend on the form of contract that you're using. And I can speak to this because I'm currently working. I'm the president of the dispute board on a road project in Central Africa where we're facing these very problems, where the contractor is saying, currency is devalued, inflation, supply chain issues is another one. I can't get the materials I thought I could get. Therefore, I'm making a claim. So that's the cost too much element of it. The takes too long is, again, fairly self-explanatory. I know Diane will speak to this later on, so I won't go into this in any more detail. Safe to say, construction contracts, you tend to have issues with delay. Contracts will usually contain penalty clauses for delay, and that gives rise to disputes. And the final and third category is falling down. Again, self-explanatory. These are defects, and defects arise in all sorts of contexts. If you are, for example, if you are building a petrochemical plant and the contract contains certain requirements in terms of performance, and when the contract is completed, the process plant doesn't meet up to the performance requirements, that will be a claim. If you're building a road and the road is defective because the substrate wasn't done properly and it starts falling apart, all of those lead to defects claims. Right now in the UK, we have a particular problem. Following the Grenfell fire tragedy in 2017, when almost 100 people lost their lives because of defective cladding, we now have a raft of cases in the UK, all defects claims, or based on defective cladding and fire performance issues. So those are the three general areas you have when it comes to triggers for arbitration and construction contracts. Costs too much, takes too long, falling down. And then how do they typically escalate? Well, they escalate because one party or the other has made the decision that arbitration is a more economic opportunity. It has the risk of arbitration is a better opportunity for them to make money than not. So most construction contracts these days will have what are called tiered dispute resolution clauses, starting usually with negotiation, then mediation, then occasionally adjudication, which I specialize in, and then finally arbitration. So to go through all those hoops and end up in a position where you want to arbitrate, one party or the other must have made a decision that it's in their interest to roll the dice and to arbitrate because they think they'll get a better outcome in arbitration. So I hope I stopped the time there, Stanley.
Thank you so much, Mr. Jonado. Thank you so much, especially for those three triggers. It costs too much, it's falling down, it takes too long. So drilling into it's too long, Mrs. Okoko, I know you've seen different delay claims take center stage in construction arbitration in recent years. In your experience, why has this become so common? And what distinguishes a strong, persuasive delay analysis from a weak one?
Thank you very much, Stanley. Good morning, good afternoon, good evening, and very early good morning to some people somewhere in the world. So remember that Abdul had mentioned that, one of the triggers for arbitration in construction disputes is, time. So let's look at, it takes quite long. Let's think about delay claims as a claim about time, in the sense that when a delay happens, and let's not take for granted that everybody knows what a delay claim is. Now, a delay claim is that claim where the contractor, and sometimes even the employer or the subcontractor, asserts that an event or a series of events have caused works to, go beyond the contracted completion time, and that claiming party is actually entitled to some remedy. So this is where we talk about a delay claim. And a delay claim could be a request for certain kinds of relief, financial relief, prolongation costs, disruption costs, even acceleration costs, right? An extension of time is at that point where you're looking at liquidated damages to say that, look, I need more time to complete this. More time is going to cost me this. And remember that a delay claim must always impact or be linked to the critical path of that project, right? Another kind of claim you will be looking at is maybe a prolongation cost or an acceleration cost where the contractor has been asked or directed to catch up in time. And to go to the second part of your question, you're asking what strengthens, and this is where I like to speak to counsel in arbitration. At the point where you're making a delay claim, you want to convince the tribunal that you're actually entitled to this claim, right? Whatever it is. So I always try to say that practically, you must have delay disputes because they're complex in nature. They consist of the facts, they consist of logic, which is, so the fact is what actually has happened. Logic is, how does this, what is the critical path that should have been followed? Now, the contract is that part or the clause within the contract that this project is happening through that has been impacted upon. And then, of course, quantum is always cost of time. So for me, a delay claim, when I sit as arbitrator, I need to see 4 elements. The first is, what is the fact? The second is, what is the logic in your making this claim? The third would be, what is the contractual term that has been impacted upon? And then the last being, what is the cost of this delay? And I would say that for a strengthened claim, I want to see that the contemporaneous, there is a coherence in the contemporaneous records. As construction arbitration practitioners, you never get tired of records at every point. And remember that I'll take you back. When Abdul says that a party has decided that they will get more money in arbitration, this is true because a party can actually begin to build records to avoid a dispute. So why do we always descend into arbitration? This is because all of those tiers have been surpassed and a party is just building towards a dispute. So we want to see that there is a clear contemporaneous agreed baseline program. The logic is there. The event has been described very fully. What this affects is there. then, you know, you must always look to see that an updated CPM, a CPM is a critical path method, right? An updated CPM shows clearly what is happening every day, every time, when, you know, so it means that without these records, a tribunal is struggling to be convinced, right? And this sits at the center of every delay claim to be successful. If you're not able to establish your CPM before the tribunal very clearly, trust me, it's almost always inevitable that your delay claim will not be successful. Then the next thing would be, I'd want to see that the notice, right? The notice chain is very, very comprehensive and is full. What this means is as soon as the event happens, has notice been given within the contractual terms, 28 days, for instance, under FIDIC, right? Have you observed the 28 days? Have you included the things that are supposed to be included? At some point, I'll talk about what every single item and what I'd like to see if I were the arbitrator, right? Then one very important thing, Stanley, before I leave is I want to see that the cost, there is a linkage between cost, between effect, and between quantum. Why? Because where you don't show me that this particular event has actually caused this, and this is the effect of this event on the overall project, and this is the quantum of that cost, then I'm not convinced as an arbitrator. So, you know, these are the things I like to see sitting as an arbitrator, which strengthens a delay valuation claim.
Thank you very much, Mrs. Okoko, for those insightful responses. Taking from what you said last, you know, particularly your responses towards what you would like to see as an arbitrator. And I'll go to Mrs. Adekoya, who also regularly sits as an arbitrator in construction disputes. And Mr. Adekoya, I would like to know, please, so we all know that the procedural complexity of construction disputes is well known, right? Drawing on your extensive experience, what recurring challenges do you encounter, and what approaches enable tribunals to manage these matters effectively?
Thank you, Stanley, and thank you to the branch for inviting me to participate in this discussion. As it's clear from what the two previous speakers have said, construction arbitration is document heavy. And you need those documents to either prove your claim or defend the claim. The challenges that I see, I will break down to what I consider to be three major challenges, especially in domestic arbitration, not so much in international, but in domestic arbitration. What I tend to see is late submission of evidence, late submission of documents. And this is either due to incomplete documentation at the time the contract was being entered into, or an unclear understanding of what is required to prove a claim. So you have a delay claim, and you filed your notice of arbitration, and you filed your processes, and you do not file the notices to the engineer, the responses from the engineer, and then halfway down, we're getting close to the hearing, and then somebody says, oh, we're preparing for the hearing, we didn't file this. And then these applications come for late submission of evidence. And sometimes the informality of contractual documentation that we get into, and I'm also speaking for domestic disputes, you hardly see these in international disputes, except in some less, I don't know the word that I would use, less open countries where they haven't had that much exposure to construction disputes and are probably getting into it for the first time. But for domestic disputes, you tend to see that the project documentation, Diane referred to FIDIC contracts. FIDI contracts are standard contracts. And then you see a Nigerian company taking a FIDI contract and amending it in a way that conflicts between the general conditions which they've accepted and the specific conditions, and without resolving those conflicts. So sometimes this becomes an issue. And sometimes people decide, oh, we're drafting our own construction contract, and then they don't take care of so many things. So that's one of the issues. Because the cases are document heavy, there's an enormous amount of documentation. And then sometimes, because counsel are not clear, they dump everything on the tribunal instead of determining which are the actual documents. So I don't need to see every single monthly site report. I only need, as an arbitrator, to see the site reports where the complaints that will justify your delay claim or your variation claim are noted by the site engineer. But because people sometimes don't understand the extent of the documentation, the idea is that every monthly site report from the beginning of the contract to the date of the dispute is dumped on the tribunal. And then that becomes a problem. And then an issue that I see also in domestic arbitration, not so much in international, is the use of experts, what they speak to, and how they present their cases. In international arbitration, if anything, what I see is expert overload. In an effort to ensure that the case is met or adequately defended, you have a quantum expert, you have a cost analysis expert, you have a delay claim expert, and sometimes they're actually crossing each other's borders and boundaries. And you have to go back and read the 3 different expert reports to determine what each party is saying. And hopefully they're all saying the same thing. What I find in domestic arbitration is we really haven't got to the use of experts for your delay claims, for your critical path analysis, to be able to explain to the tribunal why this particular incident, which happened in June of 2024, has resulted in your inability to provide the materials to fit the cladding in July of 2025, those type of things. So that's an issue that we also need to look at. I think I'll stop there for the moment.
Thank you very, very much, Mr. Dekoya, for highlighting 2 issues, the documentation and also the use of experts. So now we go to the second round, and in this round, we'll focus on that documentation issue, use of expert evidence, and also the working relationship between counsel and experts. I come to you again, Mrs. Okoko. As we know, documentation frequently determines whether a matter remains clear or becomes contentious, based on what Mr. Dekoya has said. From the outset of a project, what steps should parties take to ensure that delay, variation, and valuation issues are properly recorded and less likely to become disputes?
Stanley, my response is going to sound very contradictory, because for someone who is a dispute resolver, I would say begin your documentation on the premise of dispute avoidance. Okay, all the dispute resolvers would tell me now that I don't want, their pockets to be lined with the millions that they usually have. But, why do I say this? It's because from the onset of this project, Mrs. Adekoya has told us very clearly that construction projects or construction arbitrations are really documents heavy. And the truth is, without these records, you are unable to prove that case. So have at the back of your mind that for every single record that I have, I'm actually avoiding ambiguity, which is the dispute avoidance. However, if the inevitable does happen, I do have the records to prove. So what I believe, or I'd like to see, is most times documentation should start from the beginning of the project in a system form. So have things like a centralized claim or variation log have things such as a simple claims register. So Mrs. Adekoya said she does not want to see things like every single, weekly site reports. That's not to say do not have them. This is because you're not sure which of these you're going to need. So a contractor who I see has a very simple entry every single day, I know is going to prove his claim in variation very easily, right? Those photo logs, you just go in and all you do is take the photo and then tag. If it does boil down to you, proving that variation claim or a delay claim, then you know which one to go to. I had spoken earlier about notices. Now, for me, a comprehensive notice must have at least 7 elements, at least. The first element must be that event description, right? What has happened to trigger this notice that you're giving? And this would be maybe a variation notice. And a variation notice is that notice where it will usually be a variation order, right? It's a formal change in the order that must describe the order of the project, right? So I want to see the event description. I also want to see the contract clause that this event has invoked. I also thirdly want to see the dates and the persons involved. So you see why we go back to the documentation. We see why those site logs on a daily basis, on a weekly basis are important. That's not to say dump all, but you are targeted at what you bring before the tribunal. I also want to see, what the immediate and anticipated impact of that would be on that notice. I want to see the evidence attached. If you don't have your documentation and records, you're not able to provide evidence. I want to see the relief requested. Most times, when you find these notices, you see that the relief is not very, very clear and connected to the contract. Remember that Mrs. Adekoya had told us earlier that, what she finds is that the contracts are not as comprehensive, they're not as succinct, they're not, as well put together as they should be. Because ideally, all of these should be contractually linked. If you don't have a contract that specifies what relief happens when, then you will struggle with the notice at the time. Then I also want to see a statement of the intent to mitigate. This is crucial because, as Mr. Jinadu had mentioned, sometimes, maybe mostly counsel, just want to go to arbitration. So when you have, and I speak mostly now to in-house counsel, because when these things are happening, you are carried along. At that time, what statement have you made as to how have you requested from the contractor how he's going to mitigate this event that has just happened, right? Then also something else I think that is very important is discipline. Without a reconciliation of all of your records and your documents, you cannot have this documents that will show. It takes discipline to have all of these things as and when due, and in the state and in the form that any tribunal will be happy to see.
Thank you very much, Mrs. Okoko. Based on what we've heard, we know that documentation is very important. We've also heard that expert evidence, plays a very decisive role in construction arbitration. That's also a very helpful insight, provided by Mrs. Roberts in the chat. But coming to you, Mr. Janadu, and drawing on your experience, what factors make expert testimony both credible and persuasive in the eyes of a tribunal?
Thank you, Stanley. This is for me the very simple answer to this. There are 2 factors that make expert evidence persuasive. One is independence, Two is clear expertise. You need an expert who the tribunal accepts is actually exercising their professional judgment, their own judgment. They're not a mouthpiece for the party paying them. That's absolutely crucial. And it's amazing the number of arbitrations that I've been in as counsel and as arbitrator where you can see that the tribunal immediately dismisses what the expert is saying because the expert is simply just regurgitating the party line, exercising no independence whatsoever. Secondly, it's important you have an expert who actually knows what they're talking about. The clues in the name. You're supposed to be an expert in this issue. So you need to demonstrate whether by your knowledge, by having a very, very solid CV that demonstrates your experience, or academic writing, that you have expertise in the area you're talking about. As both Mr. Koko and Mr. Adekoya have both mentioned, construction arbitration is highly technical. When you're dealing with a delay claims are notoriously complex. A delay expert has to demonstrate their conversance with all the relevant delay analysis methodology that you come across, and they also have to demonstrate that they are across the factual background on which their analysis is based. Now, we're all entering into brave new worlds now with AI. I haven't got enough time to start talking about that now, but that's going to really change things. But I think those are the two really critical factors. And when it comes to expert evidence and the credibility of an expert, it's important that you have an expert who can demonstrate fairly recent hands-on expertise in what they're talking about. You don't want somebody who has spent the last 30 to 40 years doing nothing but being an expert, because that person will not be able to speak to what actually happens on construction sites now. Their experience was 40 years ago, which it may or may not be relevant. And it's important that we also must also be conscious of the fact that there are different legal cultures around the world in terms of expert evidence. I practice in a legal culture where it's very well established now that the duty of the expert is owed to the tribunal. The tribunal your primary duty as an expert is to give evidence to the tribunal. And not all legal cultures take that point of view. In America, for instance, they believe that the party owns the expert, and they are less willing to give the expert autonomy to enter into WP without prejudice discussions, less willing to give them latitude to express themselves freely. Those are important considerations when you're looking at appointing experts. You have to ask yourself, from what legal culture does that expert come from? What are his expectations? Thank you, Stanley.
Thank you very much, Mr. Jonathan. Still on the subject of expert evidence, Mr. Adekoya, we've also seen that the interaction between counsel and experts often determines the strength of the evidence in construction disputes. In your experience, what practices best promote alignment and result in stronger and more coherent expert presentations?
Thank you, Stanley. Counsel go into arbitration as the leader of the pack. It's their role to present the case to the tribunal, and they are in charge. And they look at the expert witnesses as sidekicks, supporters. And I think we actually need to review that mentality and ensure that counsel and experts actually work together as colleagues. And it then becomes important for counsel and expert to engage right at the beginning of the case, before witness statements are filed, sometimes before statements of claim are filed, to understand the underpinnings. Personal experience. My first experience of an oil and gas dispute, a unit redetermination dispute. Client introduced me to the expert that they were going to use to support their case. And at the meeting, the expert said, I'd like to explain something to you which will help you understand where we as the experts are coming from. You like cake, don't you? I'm like, of course, who doesn't like cake? Okay. Sponge cake. I'm like, of course, sponge cake. He says, okay, take a slice of sponge cake. The holes in the middle of the slice, or that permeate the slice, that's the oil. And sometimes those holes break up into each other. And that's how the oil flows and can flow from one field into another field. And so when you're determining a unit redetermination, you're actually trying to assess where this oil comes from. How did it get to this point? Who does it belong to? And how are you going to allocate the shares of that oil? Simple. So if counsel can work together with the experts to understand the case they are presenting, it makes it easier for the tribunal. But counsel has to get that expertise in the subject matter of the dispute. So it's easier to work with a construction law expert if you yourself understand the basic principles of construction law. If you don't understand what a delay claim is, you can't explain a delay analysis. If you don't understand what a construction claim is or a delay claim, you can't understand the critical path analysis, the knock-on effect of dominoes, for those who play dominoes, and how if one falls down, it affects the other. So those are the things that I think that counsel needs to understand, that even though they are the presenter of the argument to the tribunal, it's a joint effort, and they need to understand and interrogate the expert, which they would not be able to do if they don't understand the basic principles of construction law, even before we get into putting their claim together.
Thank you very, very much, Mr. Adekoya. Want of time, I will go to round 4, so we'll be able to give some time to the audience. And this round 4 would brief reflections from each panelist on the broader trends and practical career guidance. From what Mr. Adekoya just said, if you want to be a tribunal, you have to master the subject matter, right? So coming to you first, Mr. Jinadu, and drawing on your experience as well, how would you compare the prevailing trends in Nigerian construction arbitration with development in international practice? Just in 2 minutes, sir.
Thank you, Stanley. Yeah, I mean, Nigeria exists as part of a global arbitral community. So whatever happens out there affects us as well. But we have our own particular and peculiar issues. One issue which is global at the moment, in my view, is the question of the legitimacy of arbitration generally. This problem arises from the fact that both internationally and to a large extent domestically as well in Nigeria, the pool of people who are appointed as arbitrators is relatively small. And that leads to the same people being appointed over and over and over again. And you see this internationally. In the international context, it's the problem of the old white men getting appointed all the time. In Nigeria, we have similar issues. I think for arbitration to maintain its legitimacy going forward, we need to broaden the pool of people from whom appointments are made. And I think that's something that the Chartered Institute is doing very well. I was part of a recent exercise where we did an applied course for fellows who'd never had an appointment to give them hands-on experience of what sitting in arbitration is really like. I think Mrs. Adekoya was also with me on that course. So in terms of trends, I think that is a particular trend that those of us who practice in the arbitration space have got to be aware of. There is a challenge to the legitimacy of arbitration because the same people are seen as being appointed all the time, and that causes a problem. And just very quickly, one other issue I want to raise, if I may, is this question of the attitude of tribunals. Tribunals have to be braver. They have to take charge of the procedure, and they need to put in place robust procedures that will make sure that arbitration maintains its edge over litigation, which is that it's faster and delivers a more precise and concise decision suits the party's needs and wants. So those are the two issues I want to raise, Stanley. Thank you.
Thank you very much, Mr. Jonado. Coming to you, Mrs. Adekoya, from your experience as an arbitration litigation consultant, what two practical tips would you offer to both arbitrators on today's call and also counsel who regularly handle construction disputes?
In 2 minutes, I think what I would say is you want to make your case, use demonstratives, visual presentations. As counsel, we're used to writing everything down. Sometimes seeing it makes it clearer. So even in your submissions, if you need to, use a photograph, use a demonstrative, use a graph, explain it. It makes the complexity of the dispute visible to the arbitration panel. But you must use it effectively. You can annotate your drawings to your processes to highlight things like the critical path where things went wrong. You can use comparative graphs to show the difference in costs, either resulting from a currency fluctuation or resulting from a variation. But what you need to do is to ensure that the tribunal understands that the complexity of the case that you're putting forward in the simplest terms. And those are the type of things that the tribunal is looking at. Still comes back to the same thing, though. If you don't understand your subject matter, you're not going to be able to prepare those demonstratives, those visual aids that can explain to the tribunal why your claim should be granted, why you have showed that this delay is the respondent's fault and not the claimant's fault, why this delay is not a claim that should just be should be recompensated by time, and why costs are also an adequate remedy. And all this, I think visuals can help.
Thank you very much, Mr. Adekoya. Coming to you, Mrs. Okoko, we've heard quite a few times now that there is a need to develop expertise in construction arbitration to be able to represent your client effectively and also to aid the tribunal. Based on your experience in this subject area and industry sector, what practical recommendations would you offer to practitioners aiming to develop a robust and enduring career in construction arbitration?
Thank you very much, Stanley. I have a number of them, but for want of time, I will say just two things. The first one being, you need to understand a project life cycle. So in delving into construction arbitration, I had to go learn construction. I had to go to site. I was there, to know what the difference between a substructure and a superstructure is, to know the things that comprise variations, to understand what the life cycle of a construction project really is. So that when things are brought before me, I understand what it is, then I'm able to take a decision. So you see, I call Mrs. Adekoya my senior. I'm not going to tell you why I call her my senior, right? But it shows you that, there is a likeness in the way we think. When she talks about using visuals, I'll give you, if I may share my screen, something I use even as an arbitrator to help me take decisions, right? And this I refer to as an issues-ready matrix for the tribunal. Stanley, please confirm that you can see my screen.
Yes, I can.
Good. So what I do with this is, and this matrix helps, with showing the chronology of each issue, how it is structured, how you link it, because it helps me take decisions really, really fast. And this is what it looks like for me. So when I sit during hearings and I'm asking these questions, it's because I need to fill in my table. I need to fill in this matrix. That way, in taking decisions, it helps me. So you can imagine that a party or counsel brings this before me even before I fill in my own table. You've almost proven 3/4 of your case. So I look at it as, and these are broken down into the individual issues. So, but for the global or preliminary issues, take issue number 1, for instance. Now, was clause 20.1 notice time barred complied with, right? Then I go to the contractual clause. Remember, I had said most of these things must be linked to the contract itself. That's why the preparation of the contract is very, very important. And then I put the contractual clause there. What's the claimant's position? Mrs. Adekoya mentioned this. What's the respondent's response to this? What is the evidence you have put before me to buttress either of these positions? You know, then I talk about, was an expert called, was no expert called, and then I make my finding in 1 minute. So you see, the thing is, with this kind of matrix, it is very, very easy for the tribunal to come to a decision. And you as counsel, this is what you want to do. You want to be able to narrow your issues in such a way that it makes the tribunal, hear your story as quickly as possible and understand what you're trying to put before them. So yes, technical knowledge of the project life cycle, and then you should know the legal and procedural nuances of a construction arbitration. And then please, by all means, be disciplined enough to put proper pleadings and present them in a way that very easily convinces the tribunal.
Thank you very, very much, Mrs. Okoko. And I also wanted to reiterate something that Mrs. Roberts said on the chat now, that use of demonstratives would also be helpful, especially because there are several claims often associated with a single construction case. So thank you so much. All right, seems like there are no questions on the floor. That tells me that our panelists have done an excellent job of addressing the key issues and also breaking down the concept. So come to the end of this session by thanking our distinguished panelists for their clarity, for their depth, and for the generosity in sharing their experience. Today's discussion has highlighted 3 recurring themes. First, the centrality of documentation and delay analysis in construction disputes, the importance of procedural discipline as well as the growing sophistication of construction arbitration practice in Nigeria and globally, and the use of expert evidence. So thank you so much, everyone. At this
Stanley,
point,
I'm sorry to interrupt you. I think
yes,
we have a question. There's some questions.
Oh, I just saw.
Now, yeah.
Okay, so I just saw one now. Question is, could they share more about standard contracts like FIDIS? Okay, from Lionel. Does anybody want to take that before we hand over to the chairman of the branch?
I'll answer that. I'm happy to take that one, Stanley.
That's fine.
Yeah, FIDIC is one of the more popularly used standard forms globally for large infrastructure projects. FIDIC and FIDIC-related or FIDIC-derived contracts are used. The World Bank, for instance, standard form is based on FIDIC. FIDIC is generally seen as being the gold standard for construction disputes globally. But there are many alternatives that you have. Domestically in the UK, we have the JCT contracts. More internationally, you have NEC3, NEC4. Standard form contracts have the benefit that the clauses have been thought about carefully. They've been stress tested in litigation, so their meaning is fairly well understood, and it gives the parties a well understood allocation of risk between the parties. So you tend to find that the more successful projects in infrastructure are done on standard forms. The ones that run into real trouble are the ones where people think they're going to reinvent the wheel and make their own contracts. Or, as Mr. Adekoya pointed out earlier on, they go about extensively amending the standard forms. So that's a general overview, Stanley, of standard form contracts.
Thank you very much, Mr. Chinadu. And I just understand that we have a few more minutes given to us. So we can go to tribunal management and divergent evidence. And coming to you, Mr. Adekoya, if you don't mind. We've heard a few times today that, construction disputes are technical. But one thing we also know is that they require both procedural discipline and technical depth, right? From your experience, how do you think tribunals can strike the right balance between staying efficient and giving the necessary attention to technical detail?
Thank you for that question. The tribunal has an obligation to conduct the proceedings in an efficient manner. It also has an obligation to ensure that parties have an adequate opportunity to present their case. That does not mean that excessive, overarching extensions of time, late presentation of documents should be accommodated. I have seen that international tribunals, if there is no justification for late submission of exhibits or underlying documentation, the tribunal will disallow it. You had the opportunity to present your case at the time agreed in the procedural timetable. And this is another thing that I must point out, is that whereas I find that in international disputes, when a procedural timetable is agreed, it is maintained. Parties stick to it. But in domestic disputes, we still have that concept of court litigation. You're asking for an adjournment. You're suddenly asking for an extension of time. You agreed you needed 45 days, and then suddenly you need another 21 days, things like that. So the tribunal must balance efficiency with an opportunity for parties to present their case. And sometimes the answer to this is in costs. So if there must be an extension of time to be granted or some change to the procedural calendar, then the tribunal should make it clear that even if at this point in time, I'm not going to discuss costs, this is a matter that at the end of the dispute, I would take a position as to how your late submission or your late application has extended the time frame of the proceedings, and costs will be the remedy.
Sorry, Stanley, can I just add to that? Yes, I think that it fits in, I think, with my point I was making about the tribunal, the bravery of the tribunal. The tribunals need to exercise the powers they have under whichever procedural rule or law they're working under. And I think particularly now with the AMA, it gives tribunals quite extensive powers to be able to control proceedings, and they should make more use of that to ensure that arbitration remains the preeminent mode of dispute resolution, and it retains all the advantages that people think it should do. Otherwise, we don't want to become just a reflection of court litigation.
Thank you very much for that insight, Mrs. Adekoya and Mr. Jinadu. Coming to you again, Mr. Jinadu. We talked about expert evidence, right? And sometimes we see situations where different experts reach very different conclusions, right? In your experience, how should tribunals navigate such divergent opinions?
This is a problem that you find, particularly, if I may say so, in Nigerian arbitrations, domestic arbitrations. People are trying to use expert evidence. You have this phenomenon of ships passing in the night. The experts are not talking to each other. It's just they deal with completely different issues. The way to deal with that, in my experience, is for the tribunal to put in place robust procedural orders at the outset that require the parties to meet as soon as possible, as often as required. That very often meets some pushback from the lawyers who are nervous about letting the experts go alone in the wild and for them to have discussions without the lawyers being there. But I think it's necessary to have that procedure in place earlier on. Secondly, the tribunal needs to get its hands dirty and get into the issues. And the tribunal needs to, within reason, look at the issues, determine the issues it thinks it requires expert evidence on, and get the experts to agree basic things, figures as figures, agree something in a delay claim, agreeing which baseline program to use to measure delay. Just basic things that can end up in a position where you agree a common data set. All of these things make sure that the parties or the experts are talking to the same issues, not dealing with completely different cases, which is of no use to the tribunal. I've sat on tribunals where we've looked at the experts' reports, said, look, we can't make any head or tail of these. because they don't speak to the same issues, and we end up basically throwing away the expert evidence because it didn't assist. I think it's very important for tribunals, again, that word bravery. Tribunals have to be brave in using their procedural powers to make sure that arbitrations deliver what the parties presumably want them to deliver.
Can I jump in at this point? One other thing that tribunals should do is, once parties have indicated that they intend to file expert reports, find out the substance. Is it on quantum? If it is on quantum or it's on liability, ensure that the procedural order indicates that after they have filed their joint expert reports, they should meet, and then they should file a joint expert report indicating the areas in which they agree and the areas in which they disagree, and indicating why they disagree. One, it helps the counsel on the opposing side to be able to properly cross-examine the expert within the scope of what is at the disagreement. It also helps the tribunal to focus on where they agree. And we should not shy away from hot tubbing. Put the experts together and probably allow them to cross-examine themselves under the guidance of their counsel. We just need to get that brave.
Thank you very much, Sir Adekoya. And this actually, hints at the point made by Dr. Ability in the chat, where he talks about informing the tribunal ahead, about calling expert evidence so that parties can get adequate guidance. So Coco, coming to you lastly, recurring procedural pitfalls, right, frequently undermine efficiency in construction arbitration. In your experience, what are the most common pitfalls you've seen? And how can practitioners best avoid these pitfalls?
Thank you, Stanley. There are so many that we find as a tribunal, quite honestly. And I think this has to do with the fact that counsel before the tribunal do not fully understand construction arbitration or the project itself. Truth be told, so I'm going to approach, a response to your question from three angles, right? What we see commonly as a tribunal, what this poses as a problem, and then maybe attempt some sort of fix it, right? The first thing is late issues identification and bloated pleadings. So you see, counsel before construction arbitration tribunal try to structure their pleadings like litigation pleadings. It won't work. Reason being that by the time that you have late identification of issues, your pleadings will not fully speak to as succinctly to those issues as they should have. What I do typically is that find the issues as early as possible. Go to your pleadings to find what you have put in your pleadings to address the issues that you have brought before me as an arbitrator, right? Because truth is, you have come to me because you have an issue that must be resolved, true? Identify that particular issue for me and then tell me what you have before me in your pleadings that addresses that issue and why I should be convinced by that. The second thing is poor disclosure, right? And document management. Records. So Mrs. Adekoya mentioned very early on that disclosure is left too late. Document production is left too late. So the fix it for me is, even from the preliminary meeting, I try to make sure that I have at least 3, schedules that I pose before the parties. The first, of course, is the reference schedule. We all know what it does. But the second is a privileged log. I want to be sure from day one what it is that both parties have decided is privileged document, so that I don't waste my time later on in the arbitration with so many submissions before me. No, this is privileged, this is not privileged, this should be privileged, this should not be privileged. Address me why it should. Because that's a time waste for the parties. Then thirdly, I try as quickly as possible even at the preliminary meeting, to put before you a core bundle, which is agree on that core bundle. There are documents between you that you all agree to. Bring it as quickly as possible. Make sure that these are identified even before the pre-hearing review meeting, as quickly as possible. This, I believe, helps counsel and even the parties to begin to streamline within their minds what they should be addressing. So you have targeted, you've got targeted destinations that you want to get to. And then maybe lastly, in speaking more to what, Mrs. Adekoya and Mr. Junadu have already mentioned with regards to experts. One of the things I find that makes experts to have these bogus reports, so many reports, is because they don't have a clear scope as to what they should be, putting their reports on. It's like having a moving feast. If you wanted me to choose a bread breakfast, then give me only two options, white bread or brown bread. Don't give me pancake and give me, waffles and then tell me, no, you're restricted to bread. No, don't give me a spread. I will be tempted to go and get fries. So give them a clear scope and let them speak to that. So, amongst the many, Stanley, these are the most reoccurring pitfalls I find.
Thank you so much, Mr. Junadu.
Yeah, sorry, just to add very quickly to what Mr. Coco just said, one issue we've not discussed so far is the issue of memorial style pleadings. Memorial style pleadings in arbitration and the right circumstances, in my view, help because they deal with precisely the issue that Mrs. Okoko just identified. Memorial style pleadings require you to put a bundle of documents together at the outset with your initial pleadings that supports your claim. So at the very outset, the parties have we know what the key documents are they're going to be using or going to be relying on to prove their claim. And that, in my experience, has helped with reducing issues of late disclosure or excessive disclosure down the line.
Thank you very much, Mr. Coco and Mr. Junadu. I'll give opportunity for just very brief final thoughts in a minute. Any final thoughts from you, Mr. Adekoya, just to wrap up everything you've told us today?
Construction arbitration is a specialized form of arbitration. And if you want to practice in that area, you must know the subject matter. It's not just a question of importing arbitration procedures into a construction dispute. You must understand construction law, specific types of construction contracts, specific types of claims. So, yeah, that's my final point.
Thank you so much. Mr. Coco, any final thoughts from you?
I re-echo everything she said. It's really about training. Train yourself. Read these things. The FIDIC suites, compare between 1999 and 2017, right? Be sure that you know this thing. Otherwise, you will struggle. It's a very technical field. You must train and train and train. Even when I tell myself, I'm too old to be doing these classes, I still go and get trained. I still go for the classes. I still make sure that, I'm getting as much knowledge every single day as possible. So please, by all means, it's one field that you cannot delve into if you don't know the subject matter.
Thank you so much, Mr. Coco. And you, Mr. Junadu?
Very quickly, just to say that I'm very excited because I can see in the Nigerian legal market, there are people who are now specializing in construction law and construction arbitration. I echo everything that Mrs. Okoko and Mrs. Adekoya have said about how technical this is as an area, but we now have the advantage of the internet. There are lots and lots and lots of materials available out there. So, I mean, this webinar is an example of that kind of resource that you can tap into to build up your skills. And look, the Nigerian economy is, infrastructure, construction is a large part of the Nigerian economy. It's growing, and it's something that I think people will benefit from specializing in going forward.
Thank you so much, Mr. Junadu. I still don't see any other questions in the chat room. So on this note, I will thank our panelists again, for a very insightful presentation, telling us all about centrality of documentation and delay analysis, also telling us about the expanding role of expert evidence, the importance of procedural discipline and effective case management, both from the point of view of arbitrators, but also from the point of view of counsel. Thank you so much. I've personally learned a lot from this webinar, and I'm sure that the number of persons that have joined us today have learned, and they also aim to become experts in construction arbitration. Thank you so much. And at this point, I will hand over to the chairman of the branch, Mrs. Adebomire, to address us. Ms. Adebomire, are you here?
Thank you. I was asking them to unmute me.
Okay. Okay.
Thank you. Okay. Thank you very much. I really, really want to say thank you for this webinar. This is our first webinar in 2026 in our specialist webinar series, and this has been great. I want to say thank you to our panelists, Mrs. Funke Adekoya, SAN, Mr. Abdul Junadu, and Mrs. Dan Okoko. They are all experts. Maybe I should call them super experts in that field. They are very well known in that field. And I have learned a lot. I've learned a lot. I realized I don't even know anything. So I need to go back to school. And this is pushing me. I know I'd like to say thank you to Mrs. Roberts, who engaged with us actively, and all the other participants who engaged actively, who attended. I'm sure everybody has learned something. And for me, this is telling me that the next thing we must do is a proper master class in construction arbitration. It might not be for as many people. I mean, here we have maybe like 300 plus, but just a smaller group of people who want to get into that field. The reason why we have been having these specialist arbitration series is to open the door and to show people that it's not just arbitration. There are many, many spaces, small spaces in arbitration where one can get involved in. We've done sports arbitration, we've done maritime, we've done investment arbitration, we've done mining arbitration, we've done Islamic arbitration, we've done OHADA arbitration for those who want to look into arbitration in the neighboring countries. All these things are to show people that there are many opportunities in arbitration. It's not just a general one size fits all, but that you can find your own niche in arbitration. This one today is another example. And I'm happy that all the panelists also kept talking about you have to build capacity. You have to build capacity. Like Mr. Koko talking about going to a construction site. Well, next you're going to a construction site, please take me along. So there's so many opportunities. And it's not only, we've learned, it's not only international, it's domestic. There are some things that we may not be getting right now, but with webinars like this, like Mr. Junadu said, we learn more and we get it right. We do it more like standard all over the world. Mrs. Adekoya talks about, mixing all kinds of, you take something from FIDIC, add it to your general. We learn how to do things properly from webinars like this. It opens our eyes to know that there are better ways of doing things. And I'm sure everybody has learned something. Normally, if it's a smaller meeting, I would ask everybody to say one thing they did not know before they came for this webinar and that they have learned. And I'm sure everybody here would have something to say, except that we don't have the time to do that today. I want to thank our dear Dr. Agbelusi, Rev Doc, who keeps putting these things together so marvelously well. And the people on the back end, Chinelo, Mr. Sheila Ojo, who is head of training. I want to thank everybody. You know, it just shows us the caliber of people we have in the Chartered Institute of Arbitrators, both the Nigerian branch and worldwide. And I use this opportunity to invite those who are not yet members of the Institute to come and join us. Chinelo, please, could you put up when the next course would be? We have courses at different levels, entry level, medium level for MCIR, member chartered, and fellowship level. And we invite you all to join and become members. We call it, you receive the gold standard, or I would say the platinum standard of training in arbitration in ADR. This morning, they've talked about adjudication, mediation. You receive the platinum standard of training in all these things. And by the time you are a full member and you've been attending, you'll be able to practice at the world standard of practicing in any field of arbitration or ADR that you choose. I don't want to go on and on, but I'm just so excited. I have my mom, Mrs. Adekoya, my brother. You know, I was so glad when you agreed to attend. I'm sure if we had asked you to come to Nigeria for this, you would have come. Yes, and Diane, my darling sister, you know, thank you all. Thank you, Rev Doc. Thank you, thank you, thank you. Next month, Rev Doc, I don't know what we're doing next month, but I guess you'll get the notice. Everybody will get the notice very soon. In our next, I don't know if it's intellectual property, but I know that we still have quite a few specialist areas of arbitration. And coming out of these, we're having masterclass in sports, in maritime, masterclass in construction. Nobody is saying it, but one of the reasons why we want to go into construction too is that it's juicy, as I remember somebody once said. So, Mr. Jinadu, am I not telling the truth? Even those smiles tells me it's juicy. So thank you very much, everybody. And we look forward to seeing you all again. Thank you. Mr.
Thank you very much.
Our dear moderator, you've done a great job right from before the webinar. I know you had started working, and I'm sure you're glad that all your hard work came to a very good end. You know, thank you very much. You did a great job.
So. Thank you very much, Ms. Fabomir. And my panelists made it easier for me at the time. We're straight to the point and broke down the content for people that do not have experience in construction arbitration. What if somebody was asking is where to, you know, get things to read. And like Mr. Adibomire has said, just attend some of these sessions online, you know, read free materials and attend the masterclass. She's mentioned that there are different levels, you know, at the entry level. Feel free to approach and send an email to the TIAB Nigerian branch, and you will get all the materials and trainings that you need. Once again, thank you so much, everyone. I tell it to my panelists. Thank you so much, and I'll see you all next month. Bye.
Bye-bye.